We have cases 2016-244, 2018-230, State of Arkansas versus Joey Seymour. On case 2018-230, we have a new scheduling order in effect. This is a, on this one, it's the defendant is set for trial in that case on October 22nd, the week of October 22nd, excuse me, and with a plea deadline on October 18th. August 30th is a pre-trial date, and a reappearance ordered for July 12th.
Your Honor, if the court would bring Mr. Seymour over, what's the correct number, Rhoades?
224.
Your Honor, on 16224, I believe that is set for sentencing today, and I think that we'll be able to work out the failure to appear, which is a new charge also. I think we'll plead out both cases today, Judge.
Court will direct that Mr. Seymour will be brought over for the afternoon session of court. You may be excused at this time.
Thank you, Your Honor.
2018-108, State of Arkansas versus Belinda Drexler. This is a pretrial today.
Your Honor, as the court sees, Ms. Drexler has been at Care Ministries. When I was at the jail yesterday, she was being brought back in and processed back in. I visited with her briefly. You know, there's no pretrial issues today that I am aware of. My hope had been that she would have stayed at Care Ministries, but she explained to me that the program was just not suited for her and that she voluntarily left.
I'm going to set her down for reschedule her pretrial for June 21st date, and we'll proceed on the pathway to trial as it's currently scheduled the week of August 20th.
Your Honor, she had asked me about working out some sort of plea, and I will tell her that I just have not had that opportunity since it was about 5 o'clock when I saw her yesterday afternoon, and Mr. Chisholm and I have not even spoken about her case, so that will not happen today, Your Honor.
All right. Maybe you can get something and get her by June 21st.
Yes, Your Honor.
All right. You may be excused. 2018-234. State of Arkansas versus Harley Hoskins. This is a first appearance. Mr. Hoskins, you're before the court this morning for arraignment on your charges, which are possession with purpose to deliver a controlled substance, a Class C felony, possession of drug paraphernalia, Class D felony, possession of firearm by a certain person, a Class B felony, possession of drug paraphernalia, a Class A misdemeanor, and possession of drugs and firearms, a Class Y felony, all in proximity of certain facilities. It's listed as a Class B felony. I think it's just an enhancement provision. I don't think that's an actual felony crime, a separate felony crime. But anyway, those are the charges against you. Have you made any arrangements to be represented by an attorney at this point?
No, sir.
Your right is to have an attorney represent you. What that means is you have the right to go out and hire the attorney you choose to hire, in which case the court doesn't get involved in the process. It's just a matter of private contract between you and the attorney you choose to hire. However, if you discover that you cannot afford to hire an attorney, you're still entitled to an attorney. And if that's the situation, then you're entitled to appointed counsel. The way you secure appointed counsel is you make application to the public defender's office. We have good public defenders in this jurisdiction, and one will be appointed to your case once you make that application. I think the officer there gave you the application forms. I was going to tell you they're there at the jail, but I think you were just handed them. If that's the process you want to go through to secure an attorney, you need to fill that out and turn it in as promptly as possible so the process for appointed counsel can get started. Now, on the charges I read off, how do you now plead?
Not guilty.
I'm noting a plea of not guilty. And are you applying to the public defender's office?
Yes.
All right. I'm noting that you're applying to the public defender's office. The court will advise you that your case has been set on is on the Division 4 docket. That's my docket. We got a new... I'm going to go ahead and set your case down for trial at this time during the week of October 22nd. You'll have a plea deadline to accept any pleas that are offered. Have to be accepted at least by October 18th. I'm setting it for pre-trial August 30th. And a reappearance on July 12th. All those dates will be in a written scheduling order that will be accessible by you or your attorney in the court file, which is now digitalized. So it's accessible as a public record through what's called Court Connect, and that's something you should inquire of your attorney if you want to know more about that. The bond has been set at $15,000 cash or professional. You may be excused. (2018-224) State of Arkansas versus Christopher Rhoades. This matter is down for appearance today. Was it to confirm the attorney or?
We have been appointed. We have received discovery this morning. The only other issue that I need to address today before he's excused, Your Honor, would be his bond.
All right.
Judge Putman, this gentleman appeared, Your Honor, on May 24th. Before Judge Putman reduced his bond to $10,000. He required that 20% of that be in cash. I believe that is because this gentleman's crime is selling a $36,000. His alleged crime is selling taking $36,000 from an individual by selling to him an excavator that had a lien on it out of the state of Missouri. And Judge, the motion has been made before a tribunal to get his bond reduction. I don't think this defendant is particularly happy with that bond. However, given the nature of the fact that this man walked away with $36,000, I think Judge Putman was touched by that we have a victim in Baxter County, a young man that works hard every day and is going to lose, has already lost significantly. And I think that's why Judge Putman wanted 20% of that in cash.
You know, as best I could tell from visiting with Mr. Rhoades, I don't have access to checking criminal history like the prosecutor's office does, but I believe that this gentleman has a zero criminal history. If he has anything whatsoever, it's going to be no more than a .25. He has a gainful employment at BNSF Railroad out of Missouri. He is in our jail. He is about to lose that job. He has a residence that he can go to at 218 Carlton Drive in Nixon, Missouri. Your Honor, if his bond stays at $10,000 and it's converted to a corporate bond, we're more than fine with that. We're not asking for a reduction in the amount. We're asking that it be only a corporate bond. This man stands accused. He's not been convicted of anything.
Judge, if this gentleman can come forward and provide Mr. Cooper with the information, which all of these arguments were made in front of Judge Putman on May the 24th, every single one of those, the fact that this man hasn't stolen $36,000 before, the fact that this man has a job, I'm sorry this is impacting his life. These were the same arguments that were made on the 24th when Judge Putman reduced his bond. But if this gentleman can come forward and give Mr. Cooper the inkling that he didn't do this, I'll OR him. I'll recommend that you OR him. I can't OR him, but I can. Judge, this is a significant theft. This is a significant theft for which this man is facing, could face 20 years in the Department of Corrections. And I really don't, that doesn't matter to me. I've got a victim in Baxter County that this man's going to go to work and make money. Now, none of that's going to go to the victim, the man that he stole from. And I think that's what Judge Putman was doing when he read the same affidavit you're reading. And we've had one bond reduction. But what we have here is, I'm not happy with that. Let's reduce it again. Well, don't reduce it. Leave it right where it's at.
Your Honor, what we have is an alleged victim. What we have is a man that stands accused. What we have is a man that is entitled to a reasonable bond. I would ask the court to set a corporate-only bond of $10,000. Your Honor, this man presents himself. Mr. Chisholm wants me to try my case today. I'm here to argue a bond, not try my case. This is a new client to our office. Again, with a very low criminal history, probably a zero criminal history. He deserves the bond that I have requested.
It's accurate that he has 2 misdemeanors, Your Honor. However, the same arguments that were made that reduced this gentleman's bond to where it's at were made on the 24th. We stand here on the 31st, 7 days later, and I hear no new argument that would reduce this bond.
Well, Your Honor, if this gentleman is not given a bond that he can make, he is going to lose his job. If the argument that Mr. Chisholm is making is that this is about a restitution case, and if we go one step further, if the state is right that he is guilty, then he's got to repay this $30-something thousand in restitution. How's he going to repay it if he doesn't have a job?
Well, from the court's point of view, I respect Judge Putman's decision simply because the problem is if the individual lives in another state, there needs to be a substantial bond posted on this case, regardless of the issue of the nature of the crime. It just simply we've had a long history of having difficulty getting people who choose not to come back from Missouri. So I mean, there's got to be a substantial bond in this matter. And there does appear to be a substantial amount of loss at risk in this case if he just simply doesn't come back to court.
Your Honor, if the court wants to raise the amount and make it a corporate bond, raise it to $15,000 or $20,000, corporate only. We're fine with that.
The court's going to go back to the original bond was $32,000. I'm going to make it $32,000 cash or professional bond. That at least will require the defendant to make a posting of a substantial amount of the obligation on that obligation. He's set for reappearance next on July 12th. That'll be the bond. He may be excused. 2018-228, State of Arkansas versus Kimberly Rowe. What are the issues in this matter?
This is on a
reappearance.
simple reappearance. This is a very new case. Your Honor, I believe that as far as any issues of bond, they're going to be rendered moot now because I think Mr. Chisholm was just handed a petition to revoke her probation. So there's no further action to take today, Your
We're
Honor.
setting this matter down for trial during the week of October 22nd. October 18th is a plea deadline date. August 30th is her pretrial date, and her next reappearance is ordered for July 12th. Mr. Chisholm, is in fact there a revocation in the
There
work?
is, Your Honor, I just signed it. I don't think you've got the order, but I can read it too.
Court's going to initiate that. We can't, till that's set up, we can't really arraign her on that.
Your Honor, after visiting with Mr. Chisholm, I think even with the revocation, I think we may very well work out all of these issues, including the revocation today. So she could be brought over.
All right. I'll direct that she be brought over for this afternoon. It would be helpful, and I don't know the possibility of this, if that revocation petition could be walked through the process so that we could take care of it this afternoon.
Well, Judge, yeah, that's going to be a complicating factor, but you're going to be back here in a couple weeks?
No.
No, because the Bar Association, meaning Judicial Council, was,
Judge, at least we could accomplish to see if that's the direction we're going to go.
Yeah.
And we'll just get you
All
on
right.
next time if we can't get it done.
I'll direct that Kimberly Rowe be brought over this afternoon. You may be excused. (2018-197) State of Arkansas versus Justin Hickman. Based on what's presented, the court's going to go ahead and appoint the Public Defender's Office, not only in this case, 2018-197, which he's appearing here today, but also in case 2018-211. Both of these cases are on the Division III docket of Judge Putman. And according to what I'm reading, the judge has a scheduling order that, at least in case 2018-197, has Mr. Hickman appearing next on July 26th for a pretrial.
Is there any way I can get released with the bond today?
Judge, we've actually filed a motion. We haven't got it filed yet, but a motion to revoke his bond. It hasn't worked its.
I can make bond.
He made bond at $2,500, then what occurred? He did not appear.
What case did he make his bond?
It's in 2018-197.
Judge, he was then subsequently rearrested for theft of property on May 14th in case 18-211.
Yeah.
I don't know if he
Okay,
made
so
bond.
that's the basis of the
And then he got a second, he was arrested again on 18-241 for possession of drug paraphernalia, Class D felony. Judge, we have prepared a motion to revoke the bond. It's
What
not
was
been
that
filed
last
yet.
number?
18-241.
Has he
I'm
been
wondering-
arraigned on that charge? Do we know?
I'm wanting to be released to go straight to rehab today, if possible.
May 29th
Well,
was the
just a
following-
second, Mr. Hickman, there's a,
May 29th, Judge, was.
I'm dealing right now, got to get clarified why you're in jail and what your circumstances are.
His arrest date, Judge, I don't think he's been arraigned on 18-211. I don't think he's been arraigned on 18-241. But I haven't looked at a computer screen.
Well, that's what I'm doing now.
Okay.
I see what's happened. And on the 2018-197, the defendant had an appearance in front of Judge Putman set for May 24th. Set by Judge Putman's scheduling order. On May 24th, he did not appear on that date because in the interim he'd appeared before me and I mistakenly set his case down, the 211 case down, to appear on May 31st. I'm sure I intended that to be May 24th, but the record reflects it as May 31st. And so he didn't, Judge Putman just, when he didn't appear on the 24th, Judge Putman said, well, he's ordered to appear before Judge Webb on May 31st and didn't issue a warrant or anything. So I'm just trying to figure out, did we, on the 17th, I don't reflect that I arraigned him on that day, on 211. So I think that's what needs, or maybe he was arraigned before. No, I don't see any evidence of it. I think we need an arraignment on 2018-211. On 2018-241, he has not been arraigned on either. So at this time, the court is going to go ahead, as long as he's before the court, on the charges of, in case 2018-241, where the charge is possession of drug paraphernalia, Class D felony. How does the defendant now plead?
Not guilty, Your Honor.
And on 2018-211, where the charges are residential burglary, theft of property, a Class B felony, a Class D felony. On those charges, how does the defendant now plead?
Not guilty.
Court's going to order, all three of these cases are on Judge Putman's docket. As I said, 2018-197 of scheduling order has already been entered. I'm going to put him down to appear in front of Judge Putman on June 28th. Well, actually on all three of these cases. So he gets on Judge Putman's scheduling order. Pleas of not guilty are being entered in 2018-211, 2018-241. The Public Defender's Office is being appointed in each of those cases. And the court is going to set one combined bond of, given the nature of all three of these charges and the repeat offense, the court's making the bond $25,000 cash or surety to cover all three of these offenses. That'll be the bond.
Is that cash or pro, or is that just cash only?
I said cash or pro.
Okay, thank you, sir.
You may be excused.
Thank you.